Can you clarify the eligibility criteria for VA disability benefits?
I can.
And with a special focus on folks who, didn't have any combat service.
Sure. Here's how this works. Veterans' disability compensation benefits are open to all veterans who served on active duty, who have an honorable or general under honorable discharge, and sometimes other discharges, but at least those, and who have the following three elements: a current disability, an underlying event, occurrence, disease, whatever, in service that led to that disability, and a medical determination, medical opinion linking what happened in service with the current disability.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Tony Francis Jackson.
Welcome to Victory Over VA, your guide to understanding your VA disability benefits. If you're a veteran applying for VA disability benefits, subscribe to this podcast for the latest developments in VA disability. So, who are we? I'm Francis Jackson. This is Kristian Terrison. We're from the law firm of Jackson MacNichol, where we specialize in helping veterans get their disability benefits from the VA. So, welcome. And today we're going to be talking about a common myth that only combat veterans who are injured in combat are entitled to VA disability benefits. We'll explain why that's not correct. Now, who is this show for? Well, obviously it's for veterans, but more broadly it's for those folks who care about veterans, spouses, children, families, relatives, and friends, and even those who are simply supporting VA applicants, veterans in the community. So for all of those folks, this is your chance to learn about VA benefits, and each episode has a particular aspect of VA benefits that we will discuss and explain. Without further ado,
All right, as you mentioned, today's episode is focusing on the myth that only those who served in combat or were wounded in combat are eligible for benefits. This is one that I hear a lot from our clients or potential clients, repeated time and again. So we just wanted to take a chance to get the message out and look more closely at who is eligible for these benefits. So I guess to begin at the beginning, can you clarify the eligibility criteria for VA disability benefits?
I can.
And with a special focus on folks who, didn't have any combat service.
Sure. Here's how this works. Veterans' disability compensation benefits are open to all veterans who served on active duty, who have an honorable or general under honorable discharge, and sometimes other discharges, but at least those, and who have the following three elements: a current disability, an underlying event, occurrence, disease, whatever, in service that led to that disability, and a medical determination, a medical opinion linking what happened in service with the current disability. There is no requirement that you be injured in combat. In fact, statistically, more veterans who were injured or became ill in non-combat related ways are eligible for benefits than all of the veterans who were actually injured in combat.
Now, for a veteran who had no combat service, are there any differences in the application process or the claims process?
There is one. Veterans who incurred their disability as a result of something that happened in combat get probably the best way to say it is a slightly enhanced approach by the VA to that issue in this sense. Normally, For a veteran to establish what happened in the service, there has to be a military record. Not always, but that's the kind of the baseline. For folks where the injury was incurred in combat, there doesn't necessarily have to be such a record. There's a special provision kind of exempting that from that requirement, exempting those folks from that requirement. So that's really the major difference between combat incurred kinds of problems and those that stem from an illness or an auto accident or other non-combat kinds of events.
So this may require a little bit of conjecture on your part, but I know you're very familiar with the ins and outs of the VA disability system. So what do you think the source of the myth that a veteran needs combat service to qualify for benefits is? Where does it come from?
I think that's really from television, oddly enough. You know, you see things like these Wounded Warrior commercials and all of the television about veterans' benefits, with the exception of recent spate of advertising about Camp Lejeune, really is kind of focused on military combat kinds of actions. You'll see like pictures of a veteran carrying a wounded soldier out of combat. You'll see these commercials for Wounded Warrior. You'll see commercials for like disabled American veterans where they're handing out the red poppies in a symbolic representation of those who died in the wars. So there's a great deal of ethos or myth or whatever you want to call it that surrounds veterans' disability benefits and is primarily focused on combat kinds of injuries, being shot, being injured from a grenade, being injured from a rocket attack, mortar attack, whatever. But statistically, it is a much smaller group of people who were injured in combat than those who are eligible for VA disability benefits for non-combat kinds of reasons. So it is a myth, and I hope we can dispel that myth because there are many deserving veterans who have not applied for benefits, even though they're eligible, because of this belief that, well, really these benefits are just for people who were wounded in combat. That's not true. If you were injured in a Jeep accident, if you were injured in basic training, if you were injured in a helicopter crash, you are just as worthy and just as legally entitled to VA compensation disability benefits as if you were shot in combat.
So for non-combat veterans, are there any specific challenges for that population when it comes to applying for benefits?
Well, you may remember that I mentioned earlier that there is a specific kind of exemption for folks injured in combat from having the records. So the challenge for folks who were not in the injured in combat group is making sure that they have the records showing what the event or illness or other underlying circumstance in service was to lay the base for their claim.
And is there any difference between, say, a physical injury or condition and a mental health condition in terms of, the evidence that a veteran would be required to show?
Well, only in the technical sense that, for mental health claims, you need psychological or psychiatric evidence versus physical kinds of evidence. But no, the basic rule is the same. For entitlement to veterans' disability compensation, you need three elements. You have to show that there is a current disability, medical problem of some sort. You have to show that there is something in service that led to or is the basis for that problem. And finally, you have to show the medical connection between the event in service and the current problem. But that applies across the board, whether you were injured in combat or whether some bad driver ran into your Jeep. It makes no difference.
So what advice would you give to a non-combat veteran who believes they don't qualify or, who wants to explore the possibility that they might?
Basically, I always give people the same advice. File your claim. File a claim, start down the road. The worst that's going to happen is that your claim is going to be denied, and for whatever reasons you decide not to pursue it further. But file the claim. And I say that because the way the VA system is structured, in most instances, you cannot get benefits from a date earlier than the date you filed the claim. Now, in other legal settings, that's not the case. If you were injured in an auto accident and you don't file your claim for 2 years, you still are going to be able to get benefits or get compensation for the time you lost prior to filing the suit. That's the way the system works. Similarly, with Social Security disability, for example, the benefits can go back for up to a year prior to filing your claim. But in the VA system, in ordinary cases, with a couple special exceptions that we're not going to worry about, the benefits can only start from the month that you filed the claim. So, in fact, technically, they start from the first day of the first full month after you filed the claim. So if you filed the claim yesterday, the first day of the first full month after you filed is the earliest date that the VA can pay you if you eventually win the claim. So what I try to encourage people to do is start a claim. If you really have concerns about starting the claim, file a notice of intent to file a claim. But get something to the VA that serves as a marker that you want benefits from this date forward. Now, people sometimes say to me, well, I don't have all the information, and so I can't file a claim. Well, that's fine. File a notice of intent to file a claim, and that gives you a full year to collect any information you need and file your claim, or just file the claim. The worst that's going to happen is your claim is going to be denied, and you will need to appeal, and you can add more information on the appeal. But you can get that information in. But what you can't do is you can't ever go back and start the date of your claim earlier. So the sooner you file, the more potential back benefits you're going to be eligible for when the VA grants your claim.
Now, what assistance can an attorney help in this process, or can an attorney provide in this process for veterans claiming disability for a condition not related to combat?
Sure. The way it works, the VA is the only agency that I know of in the United States government where you cannot hire and pay an attorney to help you file your claim. The system is set up so that you have to file the claim, and if the claim is denied, or if you think the rating granted is too low, then and only then can you hire and pay an attorney to assist you. So the way that an attorney will assist you once you hire them is pretty straightforward. They'll look at the claim. They'll look at the circumstances showing the relationship to service. They'll look at the medical evidence tying those things together, and they will help you to put together the information in such a way that it is persuasive to the VA and results in an award on your claim. You'll be entitled to service connection and then an appropriate rating. It's not impossible to do these claims on your own. Many people do. Unfortunately, the VA's own statistics show that for people who file the claims on their own and don't get the assistance of an attorney once the claim is denied or rated low, they are less likely to be successful. And that's just a fact. And the reason for that is that most veterans do not have the training to understand the legal issues that the VA has relied on to deny the claims, and don't understand what information they need to get and how to get that information to resolve the issues that the VA based the denial on. In a large number of claims, really easily 90% of the claims we see, the big problem is the medical connection between what happened in service and the current disability. One of the things that we really pride ourselves on is knowing what experts to go to. We work routinely with a large number of experts and can frequently find the right expert to explain in convincing terms to the VA the reasons that what happened in service caused the current disability. And that is the crux of many of these claims. Large percentages of denials are based on the failure of that link, the lack of that medical evidence to tie what happened in service to the current disability.
Yeah, I know establishing that nexus is definitely a big part of the work we do in our office.
To the point that we've applied for a trademark for our nexus process.
Are there any recent changes in VA policies, regulations, laws that positively impact veterans claiming conditions that aren't related to combat?
Yes. Probably the biggest change in VA law in many years is the recent enactment of what's known as the PACT Act, P-A-C-T. And that is a very comprehensive piece of legislation. It became effective in August of 2022. And what that act does is to make a large number of conditions presumptive and to include some previously omitted veterans in existing presumptions. And let me explain briefly. For example, for a number of years, the VA has turned down veterans who claimed Agent Orange-related conditions such as diabetes or lung cancer, or a whole list of other things. From the Vietnam era, for veterans who were stationed in Thailand, Cambodia, or participated in the incursions into Laos. And even though, if those people had been in Vietnam itself, their claims would have been presumed to be connected to their service, that was not the case if they served in Thailand, Cambodia, Laos. And so the act now changes that presumption to include folks stationed in Guam, just to generally include most of the people who served in Southeast Asia, even if they weren't specifically on the landmass in Vietnam. Similarly, the PACT Act has extended presumptions for a lot of folks who served in the campaigns in the Middle East, such as service in Afghanistan or Iraq, and has created presumptions for exposed to smoke from the burn pits that were common in those areas, where the military would literally burn anything that was no longer serviceable, from tanks down to human waste. So it created a presumption that the people who served in those areas were exposed to that toxic smoke and could be service-connected for certain conditions arising from that.
So as a means of illustration, can you share some examples of non-combat related conditions that you've been successful in winning disability benefits for?
Sure. There are all kinds of things that happen to people in peacetime training. And we've seen everything from vehicle accidents, whether it's a military Jeep on the base or a private civilian automobile off base, but while you're still on active duty. People who are injured in training, everything from getting hurt on the obstacle course to being injured by a defective weapon or a grenade. And even though those aren't active combat kinds of injuries, they're nonetheless debilitating to the people who suffered them. And they are all examples of cases that we have been able to successfully get VA disability benefits for the folks who were injured.
I remember one veteran's case I worked on where they had injured themselves on the obstacle course. I think 3 weeks into basic training, they really shattered their wrist and it didn't heal correctly. They got a medical discharge, and over time, it became arthritic, and there were all these secondary problems, and they hadn't applied in the first instance because they thought, I was in for 3 weeks. It was basic training. I'm not entitled to any benefits. And, they had that mistaken belief for 30 years before they applied. So it's really heartbreaking. And that's why we're working so hard to get the message out.
That's true. It is sad that there are so many veterans out there who, for whatever particular variation of this myth that they're not entitled, have not applied for benefits. It's unfortunate.
Well, also unfortunate on that sad note, we're out of time for today, but thank you for tuning in. This has been another episode of Victory Over VA. When in doubt, apply for benefits. You can always sort it out on the appeal or give us a call here at Jackson MacNichol.
And we'll help you sort it out.
It's what we do. But please be sure to subscribe and join us next week.
See you then.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.